we look at section 124.8 of the Communications Act, these are all things that have been inserted into the Communications Act by the Digital Economy Act. We'll see that one of the things that the Act requires of the Initial Obligations Code is that a notification to a subscriber, and a notification is something that is sent to the subscriber up to 3 times, and then maybe a few more times if they're very bad, on receipt of a copyright infringement, or many copyright infringement notices, reports rather, by the ISP. A notification has to contain, one of the things it's got to contain, is a statement. First of all, that the ISP is going to keep information about this poor subscriber. Secondly, that the copyright owner might be able to get that information out of the subscriber, out of the internet service provider. And thirdly, that the copyright owner may bring proceedings against the subscriber for copyright infringement. And the Initial Obligations Code that we've seen in draft, we don't know what it's going to look like, but the draft we have had a copy of last year. If you turn over the page, the first notification will say that there's potentially legal action by qualifying copyright owners, and the next notifications will say that the qualifying copyright owner can go to court, find out the subscriber's identity with a view to bringing proceedings against the subscriber for copyright infringement. Now, there's nothing wrong with that. Anyone can bring proceedings. I could sue you all for something. But it doesn't mean I have any grounds to bring those proceedings. And the trouble with these notifications is that they give the strong impression that there were grounds for those proceedings as well. Now, it doesn't stop there. There's another problem with this rather peculiar wording. If we go over to section 124N, we discover that, which is over the page on my thing, copyright owner doesn't mean what you think it means. Copyright owner means, first of all, a copyright owner, but it might also be someone authorised by that person to act on that person's behalf. So copyright owner or somebody else, such as a copyright collecting society, or perhaps less charitably, somebody who thinks they can make money out of it, who's been told they can get on with it by a copyright owner who thinks, well, I might as well let someone make some money out of this and take a cut. The trouble with that is, if we turn over to, sorry for this, I'm making you work, because unfortunately it's all in the statute. And if you don't pay attention to statutes, then that is the kind of mess that we end up getting into. Section 102 of the Copyright and Patents Act, we're looking at actual copyright law, which was an issue in our ACS Law case, telling us about who can actually sue. Now, the Copyright Act does permit gives slightly more leeway than simply saying that only a copyright owner may take any action. Someone who is an exclusive licensee, or in some cases a non-exclusive licensee, can at least start proceedings for copyright infringement to protect their own interest. But if they do, they have to bring in the real copyright owner. As you see in section 102.1, they may not, without the leave of the court, proceed with the action unless the other, which would be the copyright owner, is either joined as a plaintiff or added as a defendant. So just any old person can't start copyright proceedings. In particular, just any old collecting society can't do it unless they've got a license or an assignment of copyright, which, well, some of them do, but some of the people who are going to be doing this kind of thing won't have. And even if they do start proceedings, they've got to bring the copyright owners in and get them involved. One of the issues that was concerned copyright lawyers who were actually attending the ACS Law hearing was that ACS Law didn't seem to have bothered to comply with this rule. And so we had this outfit, Media Cat, who might have had the right kinds of license to allow them to do it. Very, very, very questionable. An extraordinarily contorted argument was put forward on their behalf, very well, I mean, completely bogus, but very well, that they might actually have a right to sue, but they still haven't brought in the real copyright owners, which they should have